terrific to be here. It's also terrific to see that the cookies are available. I have to say, maybe this is shameful, but the cookies are probably one of the reasons why I came to BU in the first place. Good cookies. It's great to be back. And again, thank you, Wendy, for organizing this, and also to Ken. Thank you. So today, my research is often described as biographical legal history, or biographical historical work on intellectual property law, mostly copyright. So I think appropriately, I'm going to talk a little bit about the project in terms of my own biography and what led me to this particular research project, which is ongoing. I've been working on it already for a few years, and it will probably continue to go for a few years. And I'm very interested in hearing your thoughts afterwards and suggestions for further reading, because it's really in the development stages. So it all started during my first year of law school at BU, so 2001, and I noticed in many of the classes how people's views on what the law should be, or what outcomes of cases should be, was very often determined by their political views, so their political beliefs. You'd have the left-wing contingent of the class who would always come out with these consistent positions on the cases, and then you'd have the right-wing contingent of the class who would always come out with their arguments about how the particular cases should work. And there would often be heated debates. This was the case until I took copyright law with Wendy Gordon. And there I noticed that you couldn't make the same predictions based on the political views of individuals in the class. And I thought this was a little curious at the time, but I didn't think too much about it. I just took it as the assumption that while one's views on copyright might be very strong, the ideology was within copyright sphere, and external political ideologies didn't come much to bear on how you viewed copyright. It was all about the internal doctrine and theory and economic analysis within the copyright sphere. So I thought that until then the next year, I took a seminar run by Randy Barnett, who's since left BU, but he was running a seminar on intellectual property, should it exist? It's a great seminar, very interesting, and he was of the view that it should not, and he takes a very firm, right-wing, libertarian stance, and he believes that intellectual property should basically be abolished. So pretty clear views. But what was interesting is he also had us read for that class a 19th century treatise by Lysander Spooner. And even then, in the 19th century treatise, my eyes light up. So, 19th century treatise by Lysander Spooner, a radical 19th century abolitionist, political theorist, advocate for private post, an eccentric, no doubt. And he wrote in favor of perpetual copyright. So I thought, this is very strange. So Randy Barnett loves the work of Lysander Spooner, agrees with him on nearly everything, thinks he's wonderful, contributes to the website. Actually, he runs the website. Why is it that he agrees with him across the board on everything except for completely divergent views of copyright? At the same time, I started working on some independent research while at BU on the 19th century thinker James Fitzjames Stephen. He's not a jurist or political theorist who's very widely read these days, although there is an editing project at BU, so many of us around here have heard of him. And I was interested in how James Fitzjames Stephen's very clearly reasoned political views in diversity, equality, fraternity, his reaction to John Stuart Mill, how that informed his writings on copyright. He had been a member of the 1878 Royal Commission on Copyright, he'd written a digest on copyright, and he'd written a dissent. So I started looking at that, and I found it very difficult to reconcile how Fitzjames Stephen's views on copyright related to his political ideology. And then that took me further to my doctoral research on this commission, the Royal Commission that reported in 1878. And on the commission, I found it very interesting. In the 19th century, one of the dominant political and economic and really political party positions was the free trade advocates, free trade doctrine arising out of the anti-corn law of the early 1840s, late 1830s, Cobden and Bright, arguing basically for free markets, that ultimately if we have free markets, if everyone is able to trade with each other, this is the Christian way, it will lead to world peace. So free markets lead to world peace. This is no longer a strongly prevailing view, particularly not with the Christian element. But this is the dominant political theory of the 19th century is free trade doctrine at varying levels of sophistication. So sometimes I'm dealing with extremely detailed, reasoned, philosophical positions on free trade doctrine. Other times it's just kind of rabble-rousing, pamphlet throwing, wear a blue cornflower to indicate your support of Cobden, kind of low-level economic analysis. But what I'm interested in is not necessarily the most sophisticated thinking. What I'm interested in is how did what people thought lead to their views on copyright, even if it was very unsophisticated legal theory. On the Royal Commission, so this is much later, this is in the 1870s, free trade doctrine is still fairly dominant in political thought in Britain, less so in the US, which has been through this period notoriously protectionist, both in the sphere of intellectual property and outside it. But on the Commission, the free traders differed, they diverged on the question of copyright. You had free traders from within the Board of Trade, one witness particularly, and then one of the commissioners, who felt very strongly that you should move towards a royalty system rather than copyright law. Rather than having copyright as a property held by an author or their assignees, you would have copyright as a system of royalty that would be run and administered by the government. But others on the Commission thought that this seemed very strange coming from hardline free traders, that they would suggest that you would have a government-controlled system of allocating royalties to authors based on what the government thought these works were worth. It seemed absolutely contrary to the idea of the free market, of free competition. But then the Mallet and Farrer, these two, one of them is a member of the Board of Trade, the Board of Trade representative on the Commission, and one was a former Board of Trade member, and in fact his basically best friend, as I discovered. They took the position that copyright itself was a monopoly, this coming from, mostly from Macaulay's famous speech in the early 1840s. But other commissioners, as I said, found this very questionable. Herbert Spencer, the social scientist, philosopher Herbert Spencer, notably, as a witness before the commission, he said, how can this be? How can these hardline free traders be arguing this position of government regulating the value of books and then allocating to authors what they think that they should receive? And he argued broadly on natural rights grounds, though some of the other commissioners who you could say were in favor of strong copyright or at least maintaining the current system did not necessarily advocate copyright protection on natural rights grounds. So there were it's too simplistic to say there were the natural rights faction and the utilitarian free trade faction. When you actually look at the commission reports and the minutes, it's much more nuanced as to how the different arguments were made from either position. So going back to my research, I thought this is very interesting, and this goes back to the observations that I made as a law student. Why is this, and does this extend further? What if I go back to the 18th century? So I started looking back to the 18th century. And while I know that political parties are not necessarily a direct proxy for political ideologies, it can tell you something. So I looked at the 18th century copyright debates following the landmark case of Johnson v. Beckett, where it was determined by the House of Lords that the statute of Anne precluded any common law copyright except in unpublished works. The booksellers tried to find relief in Parliament. So they brought the booksellers bill before Parliament. And looking at the arguments that were made both for and against the booksellers bill was very interesting, because you had Whigs on either side. So it was declared by the Whigs not to be a party issue, despite Lord Camden, who was a very high-profile Whig, his very, you could say, anti-copyright statements in Donaldson v. Beckett about how a creator should seek only glory and not seek any remuneration. So, nevertheless, it was not considered a party issue in the 18th century. So on one side you have Charles Fox arguing against the booksellers bill, and on the other side you have also Whig Edmund Burke. And Edmund Burke's argument for the booksellers bill I find particularly fascinating. Burke, his political philosophy very difficult to pigeonhole in any way, but at least it is one example of a person where we have a very clearly articulated political philosophy to compare his views on copyright. And his views on copyright, he's actually arguing before Parliament for a kind of perpetual copyright, not on a natural rights basis, because he was sort of skeptical of natural rights in general. He's actually arguing for perpetual copyright on a utilitarian grounds, and it's I personally find the argument slightly reminiscent of Landison Posner's article arguing for indefinitely renewable copyright. There's some calling for indefinitely sort of renewable copyright, but very thin, and that's so Edmund Burke, 18th century. But what about the 20th century? What about, or the 21st century? Well, starting to see the pattern, I was particularly intrigued when the SOPA and PIPA controversies arose. And there you had the opposition and support for the bill coming from both sides. Also in the UK, the copyright reform has never been considered a party issue. So again and again, we see how this is what has been described by Sajicki and Sitch as copyright exceptions, thinking of copyright as somehow separate from these other external political ideologies, even though within copyright we have very strong divisions, what Patrick was describing as copyright wars, people who won't talk to each other because of their respective views on copyright. But yet the political ideologies are not predictive of views on copyright. So then I have to ask myself, well, why is this? What makes copyright different? And is this significant? Is this important? I'm going to answer the second question first, actually. The reason I think it's important is because I think that copyright is becoming and will become increasingly political, increasingly mainstream political. We saw this a little bit in the SOPA and PIPA controversies. We also see the Pirate Party, which itself notably eschews any affiliation with the traditional left-right spectrum, focusing only on internet and intellectual property reform, so as to be able to gain support from different sides of the political spectrum. So copyright becoming more mainstream, affecting more and more people, both as users and creators, we all see this, and becoming maybe more visible on a political stage. What I think that means is that we need to better understand the arguments that are being made on both sides about copyright policy and how they fit into broader political positions, and also what are the assumptions, what are the political assumptions that are being made in order to develop those political ideologies. So, for example, one of the points I make in my paper is how funny I found it when I was reading Patrick's book, Moral Panics and Copyright Wars, and he is praising this speech of Macaulay that I mentioned. How Macaulay saw it as a necessary evil, and how this is, he describes this as the greatest speech on copyright ever made, wishes Macaulay was still around to defend his views. But then, some point later in the book, he talks about free market fundamentalism and its evils and how it's dead and it has destroyed the world's economies. And then I thought, isn't it funny how he's praising the speech, but it was a speech that rested on, very much on doctrines of free market fundamentalism. And is that not contradictory? So this is why I think it's important that we examine the relationship between political ideologies and copyright. Now, why is copyright different than other areas of law, and why is it so complicated to work out the connections? But this is probably the more difficult question to answer. But I think there are a few reasons for this. Partly there's just the difficulty of people grasping the idea of non-rivalrous, but valuable good. Then it comes down to views on property law and views on and freedom of expression. And we've all seen how these can potentially conflict. Property and freedom of expression, both highly political issues, both inextricably connected with copyright policy. So often you have someone developing their views on copyright policy, if they can decide to have any at all. I mean, it may just be simply anecdotal, based on personal experience. I had a bad experience, someone ripped me off, I'm offended, so I think that copyright needs to be stronger. So you have the very, very simple kind of anecdotal position on copyright policy. Then you have the slightly more thoughtful views on copyright that might be based on personal interest or trade interest generally. And those are often interesting in connection with geography, if we look historically. So depending on, just easiest example, Hollywood. There's a lot of people in Hollywood whose livelihoods depend on copyright law. They may not simply say, oh, I think we should have strong copyright because it's in my self-interest to do so. But the arguments about copyright law are flexible enough, as we've seen, the arguments about copyright are flexible enough that they can then reason a position that would allow for strong copyright, and that fits in with their political views. So, say, for example, they're very left-wing. We have arguments in the 19th century and the 20th century saying that copyright is essentially socialistic or communist. Unlike other areas of property, it places the public good as being very important. It limits the property rights. It thinks about the public good in ways that we don't consider when we are talking about food, actual necessities. So Linda Lacey has written an article arguing that copyright is imposing a socialist value on a capitalist framework. And in the 19th century, copyright scholar T. Scruton, he suggested that copyright was fundamentally communistic. So it can fit. Arguments about copyright, strong copyright can fit into sort of a left-wing position. So personal interest, trade interest, geography can all play a role. But then if we get beyond that, so say somebody who's really trying to grapple with what they believe copyright ought to be, it may come down to what they think, what their views are on the nature of property, or it may come down to what they think about in terms of freedom of expression. Do they think that expression is more important? Or it could be simple, those issues, but then informed by more pragmatic considerations, such as a belief that in a democratic society you need everyone to have access to cheap books. So that's why copyright is different, and I've said why I think that it's important that we have these kind of discussions, because so many times in from such fundamentally different positions or even coming to the same conclusion, like, for example, Patrick and Macaulay, but from completely different standpoints. So my aim with this research is to look at individuals over the past 300 years, and I think that looking at individuals, looking at their biographies, figuring out why they think what they do or thought what they did is a way of getting to the bottom of some of the debates that we're having today. Thank you, and I look forward to your comments.
Can we just introduce ourselves?
Sure. My name is Andy Sellers. I'm the Dunham First Amendment Fellow at the Berkman Center for Internet and Society at Harvard. I'm a staff attorney at their Digital Media Law Project. So I do IP and First Amendment work.
I'm Carrie Sheehan. I'm a second-year law student here. And I'm Stacey Doken. I teach IP-related courses here.
I'm Catherine Piffin, and I will be teaching international intellectual property next semester here at Boston University.
I'm Paul Gillies. I'm a professor here. Mike Moyer. I'm a professor here at BU. Teach IP law.
I'm Denise Actors, I teach law.
Wendy Gordon, I teach IP also. Who has the honor of the first question? I'll go second.
No, you go first.
Okay. First question. It's a challenge to your interpretation of Patrick on Macaulay.
Okay.
Now, admittedly, I haven't read the speech in a while, but I used to read it all the time. Okay? So as I remember, it didn't really have a free trade basis. The arguments Macaulay made for limiting copyright were first the free speech aspects. He says very often authors don't like to be criticized, and sometimes their heirs don't even want their stuff to be published because, as he said about Boswell, sometimes heirs think that their parents don't show very well in their own work, so that Boswell's kids would never authorize Boswell's Life of Johnson. And Boswell did come across a little foolish. Second, he says it's not a natural right because it's at least not beyond death, because inheritance varies so much everywhere. Not a good argument, but again, not linked to free trade. The third thing he said was a boon to copyright, a boon to authors is a tax on readers. You don't want to make reading expensive because it indirectly encourages less salutary pleasures, dissipation, and the like. What other word? Anyway, that's enough, as I recall. And I don't see why you see that this free market fundamentalism drove the speech's conclusions when it doesn't show up in the explicit argumentation.
It does actually, and it's underlying the speech. I think all of those examples are correct. And in a way, you've really highlighted, I think, why understanding the political context of the period is very important, because maybe it doesn't seem as explicit to a contemporary reader. I think one of the main things is this description of copyright as a monopoly at all, which is a fairly radical statement at the time, describing copyright as a monopoly.
He called it a tax on readers.
He also called it monopoly.
He also called it monopoly?
Yeah. And so calling it monopoly is just a red flag to a bull in terms of the free trade and anti-porn law activists. So and this was picked up at the time. So I think in this version of the paper I do have a quotation, a response from Harriet Martineau, who saw Macaulay's speech as an absolute betrayal of their principles, classical liberal principles.
Wait a minute. Before, just to follow up, if you don't
Sure.
mind. If you're telling me the classical liberal principles are anti-monopoly, and Macaulay's speech was against the law of copyright, why was Harriet upset?
Because she was in favor of copyright. She wanted the long copyright that Talford was
But
advocating.
you said she was upset because his speech was inconsistent with classic liberal principles. And his position was anti-monopoly.
Right. But she did not see copyright as a monopoly. She thought this was sort of tarring it with a brush that was
Oh, so it
inadequate.
wasn't that he was being inconsistent with liberalism, it was that he was being inconsistent with Harriet's use of copyright.
Precisely.
So I'm interested, probably because I know very little about historical
ideology. I'm interested in contemporary issues and whether this project and the extent to which this project is going to take into account the reality of interest group politics and the influence that money may be having over legislators in today's world. So if you look at Democratic Congress people who seem to be very strongly protectionist, it turns out that many of them have constituents in Hollywood or other places where content protection is viewed as important. So to what extent does that play a role in your project as opposed to this idea of kind of political ideology that is pure and driven from internal motives?
Well, I think this is one of the reasons why I thought that this method of focusing on individuals is useful, because when focusing on individuals rather than parties as a whole, you can try to dig up their, obviously everyone's views, there's never going to be pure ideological position, of course. So figuring out actually how an individual did come to their conclusions, whether some of it happens to be their political views or some of it happens to be that this is their constituency. The difficulties in picking individuals who have articulated some kind of reasoned view on copyright, as well as have articulated or at least given strong evidence of their political views as well, to have the two sides to compare. So in a way, somebody who is just simply kind of voting, in a way, somebody who works or whose constituency is very reliant on entrenched interests in strong copyright is not going to be that much of interest to me. Do you want to follow up?
Well, I just think it's difficult in today's world to find people who are not influenced. So, for example, the pushback in some of the copyright wars now is coming from people whose constituents are in the technology space, right? So we've got these kind of warring private sector players who inevitably are going to kind of influence the political views of the people who are representing them. So yeah, I mean, I think it's going to be hard to do the contemporary examination if you're trying to focus only on people who are not.
Well,
influenced.
actually, you made a good point. I'm thinking in terms of the people that I have selected, the examples I have selected in the contemporary examples. Many of them are scholars, IT scholars who have also, like the Randy Barnett example, who have also espoused very particular, often extreme political views that I can then compare to the views on copyright. Because in a way, it's less important. It doesn't need to be a politician who has the views. The idea of the project is to try to kind of untangle this muddle and try to analyze it and also do some categorization so that we can better understand and better question the politicians who then do try to make those arguments and to challenge them.
So you're primarily looking at copyright in the context of Anglo-American political systems.
At the moment, yeah.
So to what extent does looking at the motivations of these individuals allow you to assess the cultural specificity of the assumptions underlying copyright protections? And does that feel like that's relevant to your project and relevant to your understanding of how these ideologies are motivated?
Yes, so definitely focusing on Anglo-American, it does limit it. Fortunately, one of the benefits of, one of the reasons actually I like teaching in IP in the UK is that there isn't the kind of consensus about justification for copyright that there is here. So that I find makes it a bit more fun. You get more space to theorize. I do actually use, so I say that for the examples I'm focusing mostly on Anglo-American. I do, in some of the introductory work, use some examples such as the fact that copyright continued after the revolution in the Soviet Union. So for until about 1922, copyright remained the same as it had been on the czars. I'm very fortunate to have a legal historian who focuses on Soviet and post-Soviet legal systems across the hall from me. Shall we have a view of that? And you know, obviously, I've spoken to continental academics who come at this in a very different way. I think that for the moment, actually focusing on the Anglo-American is enough because I might just extend it to Commonwealth, but we just don't have the same, I suppose, politics within copyright in some of the other jurisdictions that you do in
Yeah, follow up. And then in the contemporary context, are you looking at arguments and motivations for particular views on copyright that come from maybe a different view of authorship, a different view of authorship originality or fixation, what these things actually, what these things kind of mean in culturally different cultures?
Can you give me an example?
So, for a friend of mine did her dissertation on copyright law's impact on Jamaican music and dance culture.
Oh, okay.
And how the ideas about how works are produced are very different than what's embodied in copyright law, which tends to embody a very Anglo-American idea of originality, authorship, and fixation. So places where works are produced through repetitive cultural practices.
Well, I mean, at the moment,
sharing.
I'm not looking at those at all.
But you're not looking in contemporary context at people who are making arguments based on this idea of cultural difference in production?
I wouldn't rule it out entirely. If someone was making an argument about copyright as it relates to those cultures, or using other cultures and views of originality as an example in their work, and then also grounding this in some kind of interesting political stance, then yeah, by all means. So if you knew of a particular case study that looks promising for me to look at, then yeah, I would be more than happy to take a look and see how it might, whether it would be, I suppose, right for the kind of analysis that I'm doing.
Going back to the purposes and principles of copyright and sort of the unique moment of America deciding at the Revolution to adopt copyright, much like the Statute of Anne, I'm wondering if there's any room in this research for the discussions around the Constitutional Convention, the Jefferson-Madison, nowadays we include Franklin in that list a little bit, and these figures and their political leanings more generally and their particular views towards copyright.
Absolutely, that is very much on the to-do list.
Great.
So thank you.
Okay, this is about libertarianism.
Okay.
Okay. One of the things that's fun about copyright is it drives a wedge right into that little crack where the libertarians refuse to look in their psyche, namely the place where they deny that property is government created. That is, they love property, they hate government, they say, oh, property's not government created, it's historically, spontaneously evolved, or whatever excuse they have for it this week. And then comes along copyright, which is both property and governmentally created, and you sort of say to them, put your money where your mouth is, which is more important. That you believe that personal autonomy is furthered by property systems, or you believe that government should stay out of everybody's business. And so no wonder they fracture, okay? That makes perfect sense. They can't hide from themselves. The government will rule. Another reason they fracture is that copyright limits one's ability to use one's physical property, whether it's one's guitar to play a song publicly or one's computer to copy a song or one's sheet music. And the more emphasis you put on freedom to use your personal property, the more copyright looks like an intrusion. Again, no wonder they fracture. Are there similar systematic accounts you can give for the fracturing, for other ideologies?
Well, I would even add some to your description of the libertarianism, in that theories of value can come into it. So on the Royal Commission, when I got down into the divisions between the different free traders, there were some who espoused a labor theory of value, whereas Mallet had developed his own theory of value and rejected labor theory of value. And I kind of hoped that this would come down on clear lines. It didn't, actually. But it's yet another thing that, as you say, fractures the libertarians. But then theories of value are also very relevant to any kind of communist ideology as well. So yeah, theories of value is
But wait,
is
is there a
value.
way they would split ordinary party allocation? I'm a little puzzled. I mean, let's say you're a labor theory of value person. I can see it splitting because on the one hand you'd be pro-author because it's his labor, on the other hand you'd be pro-public because the author is building on what the public domain has built for the last 300 years.
But then
Is
also,
that the kind of fracturing you have in that?
also because the labor varies. We don't. It may have to do with the author's labor, but it's not as if we reward works that take more labor. So I think that some of the more left-wing positions have at least trying to, the attempts to apply Marx to copyright theory have definitely struck some problems with trying to justify copyright as, or even justify certain kind of rewards when it doesn't have a direct correlation to the labor that is spent on the creating work. So what other?
Well, I'm just trying, I mean, libertarians is pretty easy to see.
Why?
How they've got a central inconsistency that copyright reveals, okay?
Okay.
Is that what's happening in the other political positions?
Well, yes. So moving over to the freedom of expression area, I mean, as you know well, you can argue that copyright is a vehicle of freedom of expression. On the other hand, you can also argue that it stifles freedom of expression. So yes, you can find similarly divisive there. I think you did.
What?
So I'll preface this question with saying, this is not an area with which I'm very familiar at all, so this is completely off base, feel free to say so. But as I'm hearing you talk and kind of looking over the research agenda, it seems to me there's kind of a fundamental definitional question lurking in the background, which is, how do we define a particular person's political beliefs, right? Because without knowing anything about, I'm sure people have written about this, but without knowing anything about it, it seems that there's two ways you could view it, right? One is that people have this kind of inherent political bias, and then that bias manifests in their reactions to particular policies. Or you can flip that around and say people have this kind of collection of policy preferences, and then we kind of amalgamate them into their politics, right? And so it seems to me kind of answering the question of which direction we view that is kind of important to figuring out, how do we view the politics of somebody like Randy Barnett? Is he just an inherent kind of conservative type person, and his conservatism manifests in his preference for property rights and his antipathy towards copyright? Or does he have this kind of unique set of policy preferences where he has antipathy towards copyright, he really likes property rights, and therefore he's a conservative?
Well, in his case, he self-identified since he's, but no, this is absolutely, this is something that I've started to grapple with. A couple problems in what you said. So first of all, how do we identify, maybe you're just how to categorize.
Yeah.
One of the nice things about looking at the individuals in this way is, well, I kind of, broad brush, right wing, left wing. Obviously, when I'm talking about 18th century Whigs, I can't do that. It's very, so that's why looking at the individual, I think it gives me the opportunity to describe precisely what their political views are as stated by them. And maybe later on, I can take this and try to do some categorization and some analysis of that. But having it resting on the more descriptive. So then somebody later on can then challenge me and say, well, actually, he said this. Is that really? Does your categorization hold up later? Which would be great. But I think that focusing on the individuals is the most important thing. Later on, so that's one of the issues. The other issue you kind of pointed out is, well, how do you study political ideologies? What's political ideology? And there, thank goodness, I have discovered the work of Michael Frieden, political theorist from Oxford, who has written lots of books about political ideologies and called for the importance of studying political ideologies and has given all of these useful guidelines for analyzing political ideologies. he has done. I'm very grateful for it. And then, frankly, was there any? That was I think those
Yeah, that was
two
it. Yeah,
things.
because I was just, what was really motivating that question was just thinking of like, what we would define as kind of a conservative ideology in say like 1850.
Yeah.
It's probably much different than we define it
Absolutely.
in 2013. And so, kind of putting people into buckets over time might be difficult, but it sounds like.
But even a Whig is just such a broad term, and you have so many different factions with it. I think this is why I believe so strongly in kind of the legal, historical, contextual, biographical approach.
So I've got comments, a couple of follow-up comments. So first, Stacy was talking about intergroup politics, and I wondered if you want to respond to Stacy by saying that intergroup politics, at least with regard to copyright, were less significant in 18th or 19th century England than they would be today. I don't know if that's true, but that would maybe it would be helpful to you to say that if it is true. There's.
Let's just looking across all of these.
And I'm not sure that is true.
Yeah, well, so I'd be interested in hearing a little bit about that. So I see money in Hollywood. I see money in servers and internet infrastructure. I see lots of money and channels for the people with the money to influence politics. Was that also true in mid-19th century England? So you might say that, or fine, but so what's the nature of politics similar to what we perceive today? So and just looking for a quick response to that. The same concerns that Stacy has about the U.S. today, are they equally appropriate for England? Maybe your life is easier if they're not.
No, they are. They were still the intergroup politics.
So the stationers or the publishers then were.
The publishers were very active.
All right.
And actually, one of the interesting case studies that we'll be working on is the publisher Putnam, an American publisher in the 19th century, who bucked the trend and was arguing for strong copyright and international copyright, and many of the other publishers in America were more protectionist.
Yeah, so my knowledge of the history is almost zero, so that would be interesting to hear that sort of response to Stacy's question, go back in time and
So yeah, it's nice to find people who are kind of going against what
so
they're.
Andy's question, I really wanted to hear more about that too. When we look at the IP clause in the Constitution, there's a little bit of discussion about what people were thinking about patents, and some attempt by originalists to go back and find out what was the original understanding. I think the answer is there was no original understanding. There's almost nothing there, and certainly on the patent side, when we've tried to talk about original meaning as it connects to business methods being patentable, it's just shocking how little there is, and shocking to me that anyone claims that they can have some kind of understanding of what was originally meant. A provision of the Constitution no one seemed to pay any attention to at all. Am I wrong? Did anyone think for a moment and leave any kind of record of what they thought about the IP clause in connection to copyright? With patent, I'd say almost not. And with copyright, I think it's even thinner, since I have never seen anyone discuss copyright in connection to the IP clause.
There actually have been a few articles.
Doton Olear, right? Well, Doton talked about both. Pardon? Or maybe Malo. Oh, Malo's more patent side.
Just confused.
Okay,
Yeah.
but so we got some law professors, but what are the sources? Who's out there?
Letters.
What?
Letters, mostly.
Yeah.
So they've gone back. So I unfortunately.
These are the same letters that are used in the patent context then, or is there something different that I'm not aware of? If I've only seen this through the patent lens, is there anything else out there that I wouldn't be aware of, not because it's copyright but not patent? Is all of this merged? Is it simply patent and copyright together? Or are there distinct strands of commentary from copyright and patent perspectives with regard to the Constitution?
I think again, I've just not even really started looking at. So it's not as if I've discovered some trove that no one else has seen. So I basically know just about as much about it as anyone else from secondary sources, which rely on some primary sources, mostly letters.
So the segue.
Madison
Yeah.
and
The segue from this then is, why isn't this about patent and copyright? Why are you looking just at copyright? I don't know if that makes sense here. Why shouldn't you be talking about both at the same time? And let me broaden it a little further, but again, this could be totally anachronistic, but free labor movement in England, is it relevant here? You know, perhaps, and everything I say could be wrong, 50-50 chance, but covenants not to compete were not enforced starting in California around 1870. That came from perhaps some free labor tradition. It came from an antipathy toward covenants not to compete, and an antipathy toward conspiracies that reduced or interfered with free trade. You know, and so, or alternatively, does free labor show up later in time, but in any way with the possibly unfair treatment of music in the realm of copyright? You know, we don't care about performers. We care about composers, not performers. You know, the performers are just laborers. You know, and so it's pretty random. These questions are pretty random, but is there something that you want to think about in connection to labor or employment law, or just generally free labor ideology? Does that connect up with IP in some way? So again, with patents, England was more mercantilist than the U.S. The U.S., I guess, was the innovator in terms of novelty, global novelty, destroyed patentability right from the start of the U.S. patent system. It took a long time for England to move from novel in England to novel globally. So, you know, that seems to reflect the difference between the two countries. You might not expect, given that the U.S. was more mercantilist with our copyright, but England was more mercantilist with its patent system. Does that reflect anything significant? And lastly, what's going on in Holland? Why did they abolish the patent system? You know, what kinds of political thinking was influential in Holland, and is that connected in any way to the Anglo-American world?
Yeah, great. So starting off with, should I consider patents as well? I think this has been brought up several times now. I think I may. I think I've got enough to bite off at the moment in terms of just looking at the relationship between copyright and political ideologies. And I don't think that it will, I don't think that not looking at patents yet will.
So simple question, the authors often will be speaking only about copyright or only patent. They don't talk about IP, they don't combine the two as they're making.
Sometimes they do. In the debates in the Royal Commission on Copyrights, often they would distinguish, or even actually going back to the 18th century, they would distinguish copyright from patents on the basis of copyright being a thinner protection, doctrine of independent creation. So that comes up periodically. In the mid-19th century, you did have the patent abolition movement, and actually one of the people that I looked at, Robert Edward McPhee, was a leader of the patent abolition movement. He, at the time, said that he was in favor of patent abolition, but not copyright abolition. Then he changed his mind. So by the time of the 1878 Royal Commission on Copyright, he contributed an addendum. He then published a book on intellectual property, and it's pernicious. Shortly after that, he then published books of poetry, including poems about intellectual property and why they should be copyrighted out. I will recite some if you'll indulge me. Can I?
I think it would be lovely. I just wanted to time
Fine.
myself.
Fine.
I'm going to have to end it at 2.
Right. Disclaiming in life an unduly high pitch, I think copyright law is reserved for the rich. To authors it gives private property dower and right to enforce monopoly power. If reformers the law would with justice amend and compensate authors for the labor they spend, on a royalty principle prices would fall, and books be a gladness, a rapture to all. So very quickly, your other question. So yes, copyright and patents. Patents too, you can make the same argument that also related to freedom of expression, maybe not as obviously and directly, but definitely so similar problems. Also has a problem of non-rigorousness, being considered esoteric, but maybe less so. So yes, absolutely, one of these days. Labor and employment, I think is a really interesting point, and I want to look more at that. I'm not sure, but I think I should look out for that. So nothing comes to mind immediately, but I think I want to keep an eye out for that in my research. So thank you for that. The free trade in the 1850s, how influential was it? I think there's a really big difference in the examples that you used were in the U.S., and that is one thing. The free trade doctrine was very dominant in Britain, not so much here. Really, it was so strong there that it really characterized all political debates, where that wasn't the case in the U.S. So, I'm not sure that the issues are slightly different. So I am looking at the U.S. as well.
Sorry, which issue are you talking about right now?
Well, you had made a point about.
That was the novelty requirement of patent law in the U.S. Is that what you're talking about right now?
Yes, I think so.
Yeah, so starting in the 1790s in the U.S., your invention would not be patentable if it was known anywhere in the world. And in contrast, in England, at the same time, and for many years after, you could get a patent on an invention as long as it was novel to England.
No, that wasn't actually what I was referring to. You had made a point about.
Oh, something about.
The free labor.
I was talking about. Yeah, I was talking about covenants not to compete.
Yeah,
Then.
so that's I was making a point about
Okay.
the difference between
Gotcha.
Britain and the U.S. So this was your point about it being more mercantile.
That was the mercantile comment was about the patent law novelty requirement.
Right. So that was one of the patent law novelty requirement.
Right. And with covenants not to compete, there I'm thinking about its connection to trade secret law. And I'm wondering if that is another source for you to turn to. I suggested look at patent and copyright together, and when I brought up stuff about free labor, I was wondering if you want to look at trade secret law or the common law tradition relating to employees who are using their brains.
Okay. My guess is that yes, we're going to probably have it a little bit clearer on the left-right spectrum whenever we get into discussions of labor law or kind of big corporations versus little guys. So maybe if I did look at that, I might find it to be more clear cut.
I'm afraid we have to cut you short. Any concluding remarks you'd like to deliver?
No, I think that's. I think just thank you very much for all your contributions and for